So a new Second Amendment case is up for Supreme Court consideration because the Second Circuit refused to follow the Supreme Court's unanimous decision which barred the warrantless search and seizure of firearms within your home. So let's talk about this. But real quick before we jump into this video, if you think circuit courts need to stop defying the Supreme Court's decision, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit the website linked down below, and thank you again SDI for sponsoring this video. So like I said in the intro, a new case is up for Supreme Court consideration, and this case deals with the unlawful search and seizure of firearms by police officers without a warrant in someone's home. The case we're going to be talking about in this video is Torcivia v. Suffolk County. The case involves the use of the special needs exception to the warrant requirement to confiscate firearms based on a single call that a grandfather was acting irrational. This case is similar in nature to another Supreme Court decision we've talked about in the past, and that is the Coniglia v. Strom case. This case, Torcivia, is a lower court decision that flies in the face of that prior Supreme Court decision in Coniglia, essentially which stated that the permitless and warrantless entry into a home under the community caretaking exception is in fact unconstitutional. Because this new case, Torcivia, does not adhere to that prior unanimous decision of the Supreme Court, which barred this type of conduct, the plaintiff in this case is now seeking Supreme Court review and is also seeking for the Supreme Court to correct the circuit court's defiance and to issue a summary reversal of that decision. The facts surrounding this case, Torcivia, are in fact very interesting. Wayne Torcivia is a 57-year-old man with no record of violence and no history of suicidal attempts, depression, or any other mental health issues. Early in the morning of April 6, 2014, his teenage granddaughter called social services, complaining that her grandfather was yelling at her and was acting weird. Following the call from Mr. Torcivia's granddaughter, social services contacted the Suffolk County Police Department, who dispatched 3 officers to his home. Each of the officers, when coming to his home, agreed that there was no violation of any law and also that the granddaughter's complaints were not valid at all. However, at one point during the discussion between Mr. Torcivia and one of the police officers, the officer turned slightly and accidentally knocked down a magnetic drape which was attached to the front door. Mr. Torcivia then went to go and pick up that drape that dropped, and the officer then screamed very loudly at Mr. Torcivia to get back and also threatened to tase Mr. Torcivia if he did not get back. Mr. Torcivia then claims that he told the officer not to tase him because he has a heart condition and that he would die. However, I guess the officer said he understood that statement by Mr. Torcivia to be that he wanted to be tased and that he wanted to actually die. The police officer claimed that he heard it this way, and under that basis, they decided to arrest Mr. Torcivia and then essentially send him to a mental health institution there at the Stony Brook Hospital Comprehensive Psychiatric Evaluation Program. And essentially, it was a mental health evaluation that they subject Mr. Torcivia to because of those statements. At no point during any of these interactions did the police officers ask Mr. Torcivia if he had any firearms within his home, or did they ever indicate that firearms were ever involved in this incident. It was only after dropping him off for the psych evaluation did one of the officers learn via a computer check that he had a New York State pistol license and therefore actually did have firearms within the home. That police officer then contacted his sergeant, who then instructed that police officer to contact Mrs. Torcivia and ask her to actually provide those guns to the police department. And the sergeant also said that if that police officer was unsuccessful, then to return to the hospital to get consent from Mr. Torcivia for those firearms to be seized. However, after doing so, Mr. and Mrs. Torcivia both denied the police officer's consent to actually seize those firearms. Eventually, his psych evaluation came back clear, and 12 hours later, he was recommended to be discharged by the doctor. However, one of the social workers on his case told her intern to get into contact with Mr. and Mrs. Torcivia to get the combination for the gun safe so that they could then seize the firearms. The intern called Mr. Torcivia's wife and said that there was a change of plans and that her husband would not be released from the hospital until the firearms were released to police officers. The social worker and that intern then called Mr. Torcivia as well and told him that he would not be released until the firearms were handed over and confiscated by the police officers. Mr. Torcivia refused once again, but under threats that he would never be released from the hospital until he actually gave up those firearms. He then yielded and actually did give the combination to the safe to the police officers, and the police officers came to his house and seized those firearms. After he was released from the hospital, went home, and after all this happened, on May 6, 2014, Mr. Torcivia requested the return of his firearms from the police department. His pistol license was later revoked, and although there was a hearing over the loss of his license in late 2015, he has not since ever recovered his handguns. And it took over 2 years for the police department there to release the long guns to a gun store who then transferred them to Mr. Tresivius. So those are the basic facts surrounding this case. This issue spiraled from a baseless call from a granddaughter who was a teenager all the way to him being held in a mental health facility and then threatened to never be released until he gave up his firearms. This case made its way up to the Second Circuit for review, and on review, the Second Circuit found that under the special needs exception to the warrant requirement, the police were able to do this type of thing. In reaching that ruling, the Second Circuit largely ignored the Caniglia case and confined the only mention to that Supreme Court decision to a footnote. Now, if you're not aware, last year the Supreme Court issued a ruling in a case called Caniglia v. Strong. That case dealt with whether the community caretaking exception to the warrant requirement applied only to vehicles or it could be extended to warrantless search and seizure of firearms within a home. In 1973, the Supreme Court decided a case called Cady v. Dombrowski. In that case, the Supreme Court held that the police officers in that case had not violated the Fourth Amendment by searching without a warrant a trunk of a car that was towed after an accident. And again, they said that was valid because of the officers' community caretaking functions. The Supreme Court found in Cady that the warrantless search of an automobile under this circumstance could be constitutional, but Cady was largely based on the differences between automobiles and the home. Caniglia made its way all the way up to the Supreme Court, and the Supreme Court issued a unanimous decision in favor of Mr. Caniglia. Justice Thomas wrote for the majority, and in writing for the majority, he stated, "The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The very core of this guarantee is the right of a man to retreat into his home and there be free from unreasonable governmental intrusions." Justice Thomas therefore found what is reasonable for vehicles is different from what is reasonable for homes. Cady acknowledged as much, and this court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit warrantless entry into the home. Based on this, the Supreme Court unanimously found that the warrantless entry into the home and the seizure of Mr. Caniglia's firearms was unconstitutional. Now, going back to this case, Tresivia, the petitioners seek a summary reversal from the Supreme Court because the Second Circuit outright refused to apply Caniglia in this case. They state in their petition that, as in Caniglia, there was no dispute that the exigent circumstances exception did not apply. Indeed, this case is even clearer than Caniglia, and the Second Circuit's efforts to distinguish this case constitutes the plainest of plain error, if not an outright resistance to this court's authority. In opposition to the petition for a writ of certiorari, the government here argues that the Supreme Court should not review this case whatsoever because they claim that this is a technical issue and that there is a technical error in the arguments that warrants the Supreme Court ignoring this case. The government alleges that Caniglia cannot apply to this case since the petitioners have not made any claim that the police improperly came into his home. Then the government also argues that Caniglia and that decision by the Supreme Court does not apply because Caniglia dealt with the community caretaking exception, where this case deals specifically with the special needs exception. So the argument by the government is that the special needs exception and the community caretaking exception are too far apart for the Caniglia case to apply in this case. Now, this case is important like the Caniglia case was important because it deals with your protection against search and seizure of firearms within your own home without a warrant. It really doesn't matter if a search and seizure is done under the guise of community caretaking or the special needs exception. The reality remains that we don't want police officers to be able to come into our own homes, search and seize firearms without some sort of warrant. So this is an interesting case. We'll be keeping our eyes on this case. If you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and support the channel. One of the best ways to do that is to like, comment, and subscribe. All these things help to fuel the algorithm or fuel Algorithm rhythm. It adds fuel to his jet and signal to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys directly impact these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.